So if you follow South Carolina news and politics, you probably know that FITSNews has really good sources. And I hear all the time about how good my sources are. But we are joined today by somebody who I would say has better sources than even I do. Laurie Murray, Lawyer Laurie. There's a reason that you are so widely followed on social media and beyond. It's because you have the scoop.
Sometimes. Sometimes not. Sometimes I get it from you.
Most of the time, though.
I just yesterday posted a video straight from your article.
Really?
Yeah.
Well, gosh, now I'm honored.
Well, I try to give you credit. I forgot when I had to redo it. I had to redo it. But I went back and it got reported today. So it got pulled down. I pulled it back up after an appeal. But I have to get back in touch.
So we're trying to target your content.
Yeah, some people
What's
do
going
that.
on?
You know, there's some people who don't like me. I know it's hard to believe, but there are some people out there that don't like me.
Well, you stir the pot, I tell you that. But I tell you, we go to your page, your TikTok page, but also Twitter. You're on Twitter. Obviously, you're bigger following on TikTok.
Right.
You drove a ton of news during the Murdaugh saga. We were checking your feed daily during that story.
Thanks.
Let me ask you this. You obviously the incredible online social presence. You're also the prominent lawyer here in the Palmetto State. How do you balance all this out? I mean, it's got to be tough. Like,
I'm single. That's how I do it. I'm an empty nester. So whenever I leave my day job, I go to my night job, which is TikTok. I was fortunate enough to fall into this. It was not something I ever planned. It just kind of happened. And so when I go to work, I do my job. And then when I go home, I go live or I do a video as soon as I walk in the door. And it just becomes my night job. So I kind of work all the time, but it's not really work. It's kind of fun work.
yeah.
Yeah.
Well, and for everybody who thinks that, you and I are totally simpatico all the time, you give us a little grief.
Oh, no,
from
I
time
do
to
not
time.
hesitate.
Just today coming in.
I did.
Coming
I do
in
not
hot.
hesitate to tell you when I disagree with you. And that is frequent. But, we do agree on some things. And the bulk of the legal aspects of this case, I think we agree on. But, yeah, politically, I don't know that we agree. The judicial reform, I know we don't agree on. But we've got some issues that need to be worked out. I'll agree to that. Just don't know if the way that you report it is something that I can get on board with.
Well, that is why we love having you on, because, a lot of folks will block and censor and shout down divergent or dissenting views. We welcome them. So I'm grateful you're.
Well, the same for me. And I tell people, some people get blocked in my lives on TikTok. I don't block. My moderators do if they think you're being disrespectful sometimes. I don't block people, and I've told them not to block people. The only people I block are people who are incessantly coming after me, like the lady who came after me for my makeup the other day. I got tired of just
the makeup?
Yeah, my makeup. From the hearing, I was, they were reading into the fact that I sat behind the defense table. They were reading into the fact that I had too much makeup on, or just stating that I had too much makeup on. And, it's fine. I can take that, but I can only take so much of it. And I will block after a bit of that where it gets incessant. But if you have a different political belief in me, a different belief on Elliot Murdaugh's guilt or the happenings in this trial, I welcome those. Let's talk about it. Look, if I can be changed or swayed, great. If you can be changed or swayed, great. If not, agree to disagree and move on. But I don't block people for having a different opinion than mine.
Well, let me ask you about this, as it relates to the Murdaugh case, because it's really unlike anything we've seen in terms of the viral discussion surrounding it. And folks have really lost a lot of perspective when it comes to this case. Have you ever seen any case like it that has generated this kind of factionalism? And
No, nothing like that. I mean, I think that it's just a new era that we're in. I don't know. This is our biggest case, obviously, that South Carolina's ever had. So I think we're seeing it. Maybe we started it. Maybe we're starting this trend. But I know it's going on in the Koberger case. I know it's going on in the Delphi murder case. So I think it's just a new way of doing things. People are becoming fascinated by the court system and really expressing their desire to talk about it. So, and that's great. I love that people are interested in the judicial system, but I would hope that we would sit back and wait for the evidence to come in on specific cases. I never told anybody whether I thought Elliot Murdaugh was guilty or not guilty before this trial was over. I think that taints a jury pool. I think that it, leads to an unfair mob mentality against him. And it was always, for me, just watch the evidence and make your decision, and then we'll talk about it when it's over. And, you know, no, to answer your question, I've never seen anything like it. I think it's probably going to be harmful to the judicial system for pretrial publicity. But here we are, and this is the world that we live in.
Well, let me ask you this. You were at the hearing
Yeah.
earlier this week or last week when Alec Murdaugh's status conference was held. Clearly, it was a big win for the state of South Carolina. Is that
Sure. It was a big win.
what takeaways, aside from Justice Toll obviously narrowing the scope of this upcoming hearing considerably during that status conference, is there a path still there for the defense to get Alec Murdaugh a new trial, or did Justice Toll slam that door shut?
There is a path there, but it's a very narrow path. It's almost like she's going to poll the jury again. If you're aware, at the end of a trial, they'll say, is this your verdict? Is this still your verdict? It's almost that's what she's going to do. She narrowed it down so much to say that this juror, it has to be a deliberating juror. They have to have heard the statement and they have to have changed their verdict. It has to have had some effect on their verdict. So that's a very tall order. And I said, when she was appointed, that I thought it was a very wise choice on the part of our Supreme Court. I stand by that statement because she has appellate experience and she should know the law. But at the same time, I question her reading of the case that she relies upon, the Green case. So did she get it? Okay. The Green case, you have the United States Supreme Court case of Rimmer, which says that if there's a court official that makes a comment to a juror, then bias is presumed. And then the burden shifts over to the state for them to prove that it was harmless. So it's a harmless standard. And our Supreme Court had a comment from a bailiff to a jury member, and the court in Green said this, we're not going to do a Rimmer hearing. We're not fully adopting Rimmer in every bailiff case, over every bailiff's comment to a jury, because bailiffs are allowed to talk to the jury. So they kind of held that it was harmless on their own without having a hearing and saying that Rimmer didn't apply. But I don't know if they went so far as to say that Rimmer never applies, that we don't adopt Rimmer at all. Again, that's a United States Supreme Court case, so it's kind of hard to ignore it. But the bailiff in that case was asked about, from a juror, what happens if we can't read or reach a verdict? And the bailiff said, well, the judge will probably read you an offered charge, and then is it offered? Yes, offered. Alan, thank you.
One of
I got my A. See, I'm
one of us is a lawyer.
I'm terrible with names. So the judge said that the bailiff told the juror that the judge would probably read him an Allen charge and send him back to deliberate. That's all he said. It didn't go to the merits of the case, and that's what our Supreme Court ruled. It didn't go to the merits of the case. And we're not going to hold this Rimmer case to every single comment. In this case, in Becky Hill's case, she directly went to the merits of the case by commenting on his testimony. So is it the right ruling? I don't know. But I trust her because she's smarter than me, and she's been doing this longer than me, and she's got way more appellate experience than me, way more experience interpreting case law than I do.
Well, before I ask you about the federal implications, I think you addressed some of those. But let me ask you first, the Green case also clearly specified that the contact was about the process,
right?
That it was after all the evidence had been in. And, as you pointed out, Becky Hill's a different kettle of fish, the alleged tampering
Right.
that she's said to have engaged in. So doesn't that case actually have the potential to work for the defense, because it very clearly lays out a standard of procedural contact versus substantive contact?
If it does work for the defense, it'll be on the appeal. So, you have two things that can happen at this hearing on January 29th or after this hearing. She either grants him a new trial or she doesn't. If she grants him a new trial, then it's over, but it is appealable by the state. If she doesn't grant him a new trial, then it becomes part of the bigger appeal.
Absolutely. And
so
then
they get to determine.
And now let me ask you about the federal component that you talked about. By Justice Toll establishing state law as the predominant case that she's relying on and sort of subjugating Rimmer, does this not open up a federal Sixth Amendment case for Alec Murdaugh?
That's a little bit beyond my practice area. I don't necessarily do constitutional law and 1983 actions, but I definitely think that it would be something that could be addressed down the road. Just from my limited knowledge of it, I believe that it does. There could be a habeas corpus petition to the United States Supreme Court on his behalf.
Wow. Will this case ever be over?
I don't know.
Different question.
I mean, the thing, like, at first we were like, oh my gosh, it's so great. And you want to hear every little bit of it. And then you're like, oh, something, it's coming back a little bit. And you still talk about it. It's still part of it. But by this point, I think we're all fatigued a little bit. I'm fatigued by the case.
Well, and also, I've said over and over again, I don't like this process that we're learning more about now, but I do think the jury got the right verdict. Whether they got there the right way, that's what we got to figure out.
That's my issue. I think they got the right verdict. I don't think they got there the right way. I don't think the state proved this case the correct way.
Yeah.
I think this was a case of he was there, but I have a very difficult time believing that he pulled the trigger. And I know I'm going to catch a lot of grief from that because I catch a lot of grief from it every time I say it.
You're not afraid of that, though.
No, I'm not afraid of it because it's my belief, and we can have different beliefs. At least that's the way it used to be. But I think it was 2 minutes before they were shot, Paul was shot, they were talking about Bubba running around with a guinea in his mouth. This is not an ugly discussion. They were not fighting. And so I'd have a very difficult time believing that something happened in that 120 seconds that caused him to snap and kill both of them. I have a difficult time believing it. And that's just probably my own bias. It probably means that I would have never convicted him. But had you presented the evidence the right way, he was there and therefore still guilty, then you would have gotten a conviction out of me.
Well, and there was obviously one juror that was leaning strongly toward not convicting him, and we all know what happened there.
Right.
Be interesting to see how that plays out as the appellate process moves forward. But switching gears a little bit, I wanted to ask you, you are currently involved in a case going up against one of the attorneys who's been a household name as a result of the Murdaugh murder saga. And it's a case out of Lexington. It involves attorney Eric Bland representing a father and a son who are accused of murder, and you represent
the victims.
Yeah.
I represent the victim's family, yes.
And we did a brief story on this the other day, but I want you to walk us through it from your perspective. You've got some information that we don't have access to. Nothing new there. You're always one step ahead of us. But walk us through this case, Laurie, from your perspective and what you're seeing on this Lindler case.
Well, first of all, your article was on the conflict of interest that Eric Bland has in this case. And I think that he tweeted something out afterwards saying that he didn't have a conflict and he was ethical and whatever. This is clearly a conflict case. He clearly stated he represented both victims. He was on court TV. He corrected himself after he said client, and he said, excuse me, clients. So he's calling them both his clients, not that he is assisting with the defense of the son. It is that he is representing both of them.
But the son does have his own lawyer.
He does.
Right.
But they are apparently working together, is how he puts it. And this is a conflict that would have to be waived. And they could have gotten the proper paperwork to have waived this conflict. Absolutely could have done that. And I don't think Eric is generally unethical, so I would imagine that he did get that paperwork signed. But just because you can doesn't mean you should. So
walk us through why is it we're talking about dual representation, about
Correct.
one attorney representing two defendants charged with the same crime. Walk us through why this is such a difficult, murky, dubious ground.
Because a lot of times the only defense is, he did it, they did it, she did it, whoever the co-defendant is. Sometimes it's your only defense. And to represent your client to the best of your ability, which is what you are required to do under our lawyer's oath, if you are representing your client to the best of your ability, you have to be willing to point the finger at the co-defendant if that's what it takes. And in this case, he will not be able to do that because he represents both of them. So he's signing off and saying immediately that that is not what he will be willing to do. And in doing that, if that does become the defense or should become the defense, he will have to be disqualified because he's seen both sides of the evidence and represented both parties. So it's just not something you should do. And one of the things I said on X was that there are probably two criminal defense lawyers in this state that think that that's okay. And that is, Gil Bell and Eric Bland, the two who are involved in it. No other criminal defense attorney would do that.
So you don't buy his statement that he's just consulting for the
He
other
called them his clients
Encore TV?
on Court TV.
Fair enough. Let me ask you this, though. Your knowledge of this case, one of the things that I found interesting was Attorney Bland made the comment about how the case would raise issues of people bringing weapons onto other people's property. I guess he was accusing the victim of bringing a weapon onto the Lindler's property. But here's my question back. Did they not bring weapons
Exactly.
onto your client's property and then
Exactly.
kill him with
And were
the
they
weapon?
trespassing when they were on his property like he was on their property? I know that there were no trespassing signs on the Lindler house, but the victim's mom in this case, and let's just call him by his name, is Kevin Newhouse.
Yeah.
The victim's mom, Joni, was there. She came out on the front porch. They were knocking on the door. She came out. He said, I wanted to talk to her husband, Kevin's father, and he wasn't home. He had left for work. So she was there. I'm sure she asked him to leave her property. Either way, you've got a man who is not allowing the son to come inside. And Kevin, by the way, didn't say anything during this time. She said his demeanor was very different. She thought he was terrified, and he did not say a word during this entire exchange. So he started walking towards the backyard, Kevin did, and Mr. Lindler, every time he tried to move, would put that white stick that he had in front of his feet to stop him from leaving. He tried to go in his house, and Mr. Lindler stopped him from going in his house.
Prevent him from going in his own house?
Yes.
Now, that is consistent with what the law enforcement narrative of this case has been. But let me ask you this. You've obviously been investigating on your own. As you look at this case unfolding, where is again, help me understand exactly, your client's argument is that the Lindlers trespassed on their property,
Yes.
impeded the access of your client to his own home.
Right.
But wasn't he armed as well?
So he had a machete. And let's talk about that, because everybody thinks, I think when you think of a machete, you think of like a samurai sword.
That's
but
what
it's
I
like,
think of.
Massive. It's like this big. I mean, it's a curved knife. It is like literally this big. People use it to clear. And that was one of Kevin's activities. One of the things he liked to do was go in the backyard and clear brush, because they live in an almost overgrown area. So he also carried it. Eric Bland talks about how dangerous this neighborhood is. And the family doesn't even dispute that. They've been there for so long, though. They're not going to sell their house and move. But it is so dangerous. He needs protection when he's walking around. So he's carrying his open carry machete, for protection, because he also uses it to cut brush. There are also snakes that are around. He had a valid reason to be carrying, and it was not to harm anybody. Again, think about the fact that numerous neighbors had seen him carrying this machete around, and nothing was ever done. He never harmed anybody. So why is it now that this is the deadly weapon that is, he's using to harm them? Mm-hmm. Either way, he had it when he was at their house. At some point between that house and his home, Kevin's home, he was disarmed. When he came up to the front steps, he did not have that machete on him. At what point he was disarmed is a question of fact, but I can tell you what Joni, who is the only witness to this case, is going to testify to, and that is that he was not armed. So we'll see. Yeah. I think that the weapon ended up in the back of the Lindler's truck. But, and I say weapon, machete, I don't think he ever intended to use it as a weapon. But either way, you've got a man who was disarmed, and they're claiming stand your ground on his property with an unarmed man. And honestly, if anybody had the right to stand their ground, it would have been Kevin Newhouse.
You think this case pleads? You think it goes to trial?
Well,
also, there's a civil component to it. How does this unfold over the next couple months?
That's a good question. So the first thing that happens is that there will be a stand your ground hearing to determine whether he is allowed to use, or they are allowed to use, that defense. And let me just, with the stand your ground law, this it's a regular self-defense law, but it takes away the duty to retreat. So you don't have to retreat is the difference between self-defense and stand your ground. But for this to, to fly, you have to prove that you are in a place that you're lawfully able to be. You are fear for your safety. You are in imminent danger, and a reasonable person in your position would also fear for their safety of great bodily harm. You have a young 36-year-old, and I'll show you the picture. I did bring some pictures
Yeah.
just so he has a face.
Please.
This is probably what he looked most like whenever he was killed. He had been staying with his mom for a while, but da-da-da. This is also him when he was a little bit younger. So he does have a face. We're not just looking at the Lindlers. But, whenever he was in his yard and he's in the backyard, they're now back in the backyard. His mom is literally less than 5 feet away. He's unarmed. The son comes up behind him and puts him in a chokehold. And the dad says, let him go. So the son throws him down on the ground. Now, the son got out of his truck carrying a firearm on their property. So he throws him down on the ground, and then the dad says, shoot him. And he did. And he shot him 4 times. And it was not a shoot to wound, a shoot to protect yourself. It was a shoot to kill. There were 4 shots. One was to the skull, one was to the carotid, one was to the lung, and one was to the femoral artery. It was a shoot to kill. So you have an unarmed man who is on the ground, and you have a shoot to kill. So I don't know how stand your ground applies in this case, because to me, a reasonable person is not in imminent fear of their safety when it's 2 against 1 and that one is on the ground unarmed. So that is the burden that they have to overcome. Now, I know that they said, this is the other thing that we needed to address, they said that they were injured by the machete, but I can show you, this is, a picture taken after the murder. This is them standing by the truck after the murder. Now, this is the pole that he was using that Eric Bland calls a half of a broomstick. Does it look like a half of a broomstick? It looks pretty dang tall to be half of a broomstick to me. But it was used to direct his traffic. But if you get closer up and you zoom in on these, Mr. Lindler Senior is wearing these gloves that are electrician type gloves. So I don't see any blood on him. I mean, he may have had a small cut, but it definitely was not a massive wound that he was, seeking medical attention for immediately. And then last photo, this is Junior. Not a wound on him. So you have a guy who has been unarmed and thrown on the ground and then shot. That is murder. I don't care what your last name is. I don't care who you're represented by. That is murder.
Well, that's obviously the way the Lexington County Sheriff's investigator saw it. That's obviously the way that the Office of 11th Circuit Solicitor Rick Hubbard saw it. Will it be Hubbard's office that argues at the stand your ground hearing?
It will be, because they're not going to pass that off. The only thing that people do sometimes is pass cases off to the Attorney General's office, but it will be Hubbard's office that argues it. And again, the thing is,
he's a hell of a prosecutor, isn't he?
Yeah, he is. Yeah,
he's really
they're
good.
very good. And you have to give credit where credit's due, even when you're on the defense side. He's a hell of a prosecutor, yes. But at this hearing, at the bond hearing, the Lindlers had over 500 people there. It was a fire hazard in the courtroom. So they have all of this support, all of this family in Lexington County. The Newhouses have none. I mean, they have a very small family. The mom wasn't even able to go to the bond hearing because she had COVID. So they were unrepresented there. But you've got all of these people there. The thing is that when you have a stand your ground hearing, it doesn't matter who you are, doesn't matter who represents you. A judge has to look at the law and see if it applies in that particular case. So I have every belief that the judges of Lexington County, and there are 2 permanent judges there, I believe that the judges of Lexington County will see that this is not a stand your ground case, and I don't think that'll fly. And that is when you start talking plea.
Now, let me ask you this question then. Will that mean that the Lindlers and your client will be drinking from the same cup of justice at that point?
I don't know.
I'm sorry, I had to go there.
I don't. That,
Forgive
usually
me.
the cup of justice
It
has a
was
little
too
hole in
easy.
it for me.
It was too
I've
easy.
not seen one that's actually full yet.
Well, let's talk about this because obviously you've gone back and forth with that crowd.
Yeah.
They apparently are targeting you on some of your,
As recently as today.
as recently as today, on some of your videos.
Yeah. I did a post from one of your stories. I have a series. I hate to even say it because I get such trouble for my language, but I have a series of videos that I do that is the cup of justice reality. I expose, when there is abuse of office or anything, when there is just problems with our politics in the state of South Carolina. And I call it South Carolina's a shit show. And those are my videos. There's a whole playlist of them. Anytime I see something that I think is not fair, I put the video in there. You did an article about the officers in Lawrence County who shot and killed the dog and then weren't terminated for that, but were terminated for some posts on a dating app. And so I did a video on that. And just today it was reported for sexual exploitation and gender-based violence.
Oh my gosh.
Now, I appealed it once I saw it, and it was restored within, 10 minutes. But, just the fact that somebody's out there watching and going to report everything I do, they're trying.
Yeah, we'd had something that was a video we'd done in the Stephen Smith case. We interviewed an investigator who presented an alternate theory to what may have happened to Stephen Smith, obviously the Hampton County teenager whose death for a long time was linked to the Murdaugh family. This guy turned out to be right, the investigator, and yet that video was reported for misinformation by some of these same people, apparently.
And I believe they were talking about how best to report it.
Unbelievable.
In the group.
We talk about, how do we respond to things like this? And I always struggle because, to me, that is bullying. We get accused, you and I get accused of this stuff, but to me, it would never occur to me, even if I watch someone else's report and know that it's wrong, it would never occur to me to try to organize a bunch of trolls to take a video down, or it just wouldn't occur to me.
Me either. But, and we talked about this before the interview. I don't want to get into, another battle with them. I never intended to. I never intended to be the focus of their, ire or their anger. But somehow it ended up that way. And the only time I have ever done a video related to them or mentioned them in a video is in response to the things that they have said about me. And then believe me, I was, 40 minutes of ranting by them on their podcast. The only thing I've ever done is respond to the allegations that they make about me and tell them how wrong they are. But, it's definitely something that's there. I don't block people, like I said. I don't understand why that happens, that people think that that's okay. But it's the nature of what we're dealing with now.
Yeah. It's a crazy environment, isn't it?
It is.
Sometimes I feel like Dr. Frankenstein with that crowd.
I don't know. My problem is that this is a big
I don't know if I need to apologize to you for my role in this whole process.
We both reported on the complaint against Becky Hill.
Yeah.
And, I caught a little bit more grief than you did because I used some language that people found offensive. Mm-hmm. And now they have weaponized the Office of Disciplinary Counsel and filed a grievance that could cost me my license. Even though, the best media attorney in the state says that I was within my First Amendment rights, and I stand by that. I was reporting the allegations of a complaint, whether they're true or not is irrelevant because they were the allegations of the complaint. So what I said was true. But, I am facing a lot of backlash from that. And I didn't even remember where I was going with that, but I just know that I have never come out. I've never been one to file a complaint on another lawyer, even if I see something that is wrong, because that's not my style. If it's completely unethical and I think you're misrepresenting your clients, then I would probably report that. But advertising issues and, petty stuff, I'm not going to do that. That's the same thing as reporting videos and reporting content. But I don't know what I was going. My problem is that when people come at me on a personal level on Twitter, and that's really where it happens. Most people are very supportive on TikTok. Obviously, I have 600,000 people, almost 600,000 that are supportive. So it's a rougher place for the people on X to be. But I've gained some support on Twitter, and so I like that, and it's making me feel a little bit more at home over there. But again, my problem is that whenever somebody says something to me, I can't let it go. You know, I have a friend who keeps saying, "Be Elsa, let it go, let it go," and he's gonna love that I quoted him on that. But I can't do it. I mean, I constantly have to. I have to. I don't know if it's a need to have the last word. I mean, eventually I do get tired and say, okay, there's no arguing. You can't have a rational discussion with an irrational person. But when somebody makes comments about me, it is very difficult for me to ignore them. So,
Yeah.
you know, like I said, somebody posted the other day and made a jump about me sitting behind the defense table during that hearing, the Murdaugh hearing this past week. And truly, the reason why I sat on that side was it had the better view, and it was away from all you people in the press, you know, because there was a lot of milling around up there, and there's an aisle where people, that's the main aisle that people walk up and down. But so I have to go in and respond to that. I have to respond
We
to,
could hear all the conversations on the half of the courtroom, the
yeah,
prosecution side. Yeah.
yeah. But it wasn't that I wanted that. I wanted the quiet. I wanted to be over out of the way of people walking down the aisle, and I wanted an aisle seat. I don't like getting caught in the middle of those pews. It's awful. So, but you know, the leap was made, and then somebody commented about my makeup, and it just goes like, you know, petty from there. But I have a difficult time letting that go. I have to respond. It's just who I am.
Well, you are always welcome to come here and respond. And let me say this, in addition to being a hell of a lawyer, in addition to being somebody whose sources have been spot on the Murdaugh story and many other stories from the beginning. In fact, when I put that tweet out about you not long ago, talking about how your sources have always been right, yeah, hell, I even got your haters spilled over a little onto me.
Yeah.
But in addition to that, I also want to tell you this. I don't have any problem with your makeup. I think you look great.
Thank you.
But Laurie, seriously, anytime you want to come on, especially keeping us updated on this Lindler case,
Yeah, thank you.
please come back, let us know. And if they ever shut your microphone down again, you can always come to these.
Well, I appreciate that very much. Appreciate you being willing to talk about the Lindler case, because I think it's important to catch up to the media that has been put out there by Eric Bland. One side has been heard. The other side hasn't. And I will say just the last thing, you know, just imagine if your son was shot 5 feet away from you, and this mother has been through it. So it's important to get her story out and to humanize Kevin and not just call him the victim in this case. So I appreciate you allowing me to come on here. I was waiting on the ferns to be between two ferns, but, you know, maybe next time we'll get some ferns in here.
Yeah. We'll get Dylan to get some ferns in here. We'll hook it
Between
up.
two ferns. I love that little series. But yeah, this was great. I appreciate you talking to me. And I do like the fact that we both catch grief. I catch grief if I post about you. You catch grief if I post, or if you post about me. This is probably going to make heads explode right now.
Well, good. Good. Some of those heads probably need exploding.
I think so. Maybe so. But it's good to talk to you.
Absolutely. Come back anytime, Laurie.
Thank you very much.